California. So joining us right now, once again, is Joe Infranco, Senior Counsel, Alliance Defending Freedom, who came on with us last week when the decision on Prop 8 was announced. Hello, Joe. How are you?
I'm well, and good to be with you, Steve.
Thank you. Okay, so explain what you did on Saturday, what Kennedy did yesterday, and what your next move might be.
Well, sure. You know, we all understand it undermines public confidence in the system when a court acts contrary to its own statements. Pardon me. Well, the Ninth Circuit had stated in this case that the stay it issued was going to continue until the final disposition of the Supreme Court. Well, the final disposition from the Supreme Court comes 25 days after the decision is issued. In this case, it was June 26. Well, what happened instead was the Ninth Circuit immediately lifted the stay. It disregarded the process. And, you know, what I'm told, and this was reported in the news, so I'm going to assume it's true for the interview, minutes after the Ninth Circuit issued its order, the plaintiffs were online to get married or to get their marriage license with the state attorney general Harris presiding. So clearly there was some communication on this, and it looked like the court pretty clearly violated its own rules and the rules of the circuit.
So is this a technicality? Because when we had spoken, so that's why you went and filed on Saturday, and Justice Kennedy basically said, well, I'm not going to stop it too bad, correct?
That's correct.
Okay. But when we spoke the day of the ruling, you were of the legal opinion, and Kendall Coffey, who we had on Thursday, actually, not that you need his backing, but he actually said that was good legal thinking, and it was probably legally, technically true. You said that Prop 8, in order to be overturned, would have to be overturned and have an appellate court decision. But because the Supreme Court, in its decision on Prop 8, vacated the appellate court decision, all that stood was a single judge, and under the California Constitution, that wasn't good enough. So is that still a factor, or is that? Yeah,
well, we're still pursuing that. It's not the end of the road. We're exploring all options. You see, once that occurred, once the appellate division decision or the federal appeals court decision was vacated, it left us with an order that applied to the original parties to the lawsuit. So you're talking about 4 individuals. It could not be the basis of a statewide injunction. Now, these are more than nice legal technicalities, but how these things are going to play out, frankly, is very complicated. That's why we are doing all kinds of research and looking at all of our options. There are options in the federal court and the state court. But essentially what the Ninth Circuit did was it bypassed the period of time in which we would be looking at these things and urging the trial court how to redo its original order with the injunction. And now the Ninth Circuit just kind of pushed that all aside. So that's what we're facing, but it's not stopping our overall strategy, which is we're exploring our options, and we're going to take further action on it.
Further action would be what? You go first to a lower court in California, and if they deny, then you go to appeal it, and if the appellate court denies, then I'm just, looking at.
I'll just say the exact nature of the action is not certain right now. There are ramifications to anything you do, and because there are options between the state court and the federal court, we're carefully looking at how things could play out. So we're still going forward. The exact course we're taking is uncertain. But in our view, it remains, Proposition 8 remains the law of the state of California because there is not an appellate court decision striking it down.
And if you have solid legal grounds, and I'm not a lawyer, so I ask you this question, and given the magnitude of the case, given the fact that Justice Kennedy, although you weren't arguing on those grounds yesterday, given the grounds, the fact that Justice Kennedy refused to stop the marriages and they're going forward, does that hurt anybody, but you especially here, legally, even though even if everybody says, yes, that's the law, you have a legal point, you have a legal case, but does that necessarily matter is what I guess I'm asking.
Well, it certainly creates some sort of perception of momentum or something like that. But bear in mind as well, there's some number of thousands of marriages, of so-called same-sex marriages, that took place in California in an approximately 4-month interim period between the state Supreme Court ordering it and the passage of Proposition 8. So if you add, some additional number, it's not usually important. It's not really a substantive issue. As I said, there is something about the momentum, because I think there's an effort on the other side to foreclose the debate. And what we're saying is we need a robust debate to continue, because marriage, the union between a husband and wife, is a timeless, universal, and unique arrangement. The interests of marriage, according to the government, are related to the interests of children. The fact that every child needs a mother and a father, and that there are very significant public policy questions that have to be answered in this debate. Do we want to create, by government sanction, relationships that intentionally deprive a child of either a mother or a father? Do we need to discuss that issue further? Do we need to look at social science evidence? Why the rush to head into this? So the other side, I believe, is attempting to foreclose the debate, to get people to think this is a foregone conclusion, and it is certainly not.
Okay,
we have 38 states that still define marriage as one man and one woman, and this is a nationwide battle, a nationwide debate. It's going to continue.
So, as I let you go, to people in California specifically, and other interested observers outside of California who say, can you save Proposition 8? Can you eventually, whether it's today, tomorrow, or in a year or 5 years or whatever, however long it takes, can you save the integrity and the meaning and save the proposition itself? And you say what?
I would say it's possible. There are arguments to be made. It's certainly more difficult after what the Supreme Court did, because our proponents no longer have standing. So it requires finding different interests to be represented, or for the proponents. So the proponents are the people who qualified the proposition, put it on the ballot, ran the campaign. The proponents still have standing to go back to state court, and they could raise the federal claims in state court.
Right.
Because those federal claims have not been discussed on the merits. Proposition 8 was not struck down. It was not found unconstitutional. It was simply held that the proponents did not have standing.
Right.
So I would say that it's not the end of the line. It was clearly a setback, but the future of Proposition 8 remains, in my view, up in the air.
All right, Joe. Thank you very much, sir. Really appreciate it. Now, we look forward to talking.